And with that, I will introduce Paige. Paige is currently the Director of Civic and Corporate Programs for the Nashville Area Chamber. Anderson joined the Nashville Area Chamber team in July of 2012 and has held 4 different positions within the program and events, growth, and member values teams. In her current role, she leads the civic and corporate programming along with the annual Leadership Study Mission Intercity Visit. And with that, I hand things over to Paige.
Awesome. Thank you, Emily. It's so great to be with you all. And thank you again for the kind introduction and allowing me to be with you all. So being a native Nashvilleian and working for the Chamber is truly a dream. I know several chambers and cities have felt this way, but Nashville really thrives on being a community, being in person, feeling that energy of in-person events. The pandemic really forced us to totally change what our bread and butter was, what we really thrived in. And so really looking at things differently. So as things continue to improve, vaccination rates, infection rates, all of that are looking good. And we are ready to get back to be in person for meetings and events. And we know that many chambers are facing the same legal questions that we are facing. So super excited to have Jeff with us today. A little bit about Jeff. He is one of the nation's leading nonprofit attorneys and is also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C.-based Tenenbaum Law Group, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable law firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, and is one of only 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, and currently serves as the chair of the American Bar Association's Trade and Professional Associations Subcommittee, and is on the ASAE Legal Advisory Council and Public Policy Committee. So Jeff, thank you so much for being with us. We are pumped to toss lots of questions your way about the legal implications of all things meeting in person with meetings and events. So if you all have questions, please use that chat feature like Emily mentioned. We would love to get to as many questions as possible. So we will go ahead and get started with one question that I think is top of mind. Jeff, from your experience, what are a couple of things that you're seeing that are really things that we need to be thinking about that maybe we may not have thought about before the pandemic?
First, thanks for the kind introduction, and thanks for having me here today. Nice to see you guys again. Maybe if you could, Paige, narrow that down a little bit. That's a pretty broad question. Are you talking about in the association meeting setting or other contexts?
Yeah, so thinking through, I know a topic for us has been, do you have somebody sign a disclaimer or a waiver? Do we have liability if someone were to come to an event, maybe not know they have COVID, but then it's traced back to our event? What does that look like? We never really had to worry about that before, and would just love your thoughts on that.
Yeah, so there's a lot of different issues here, and the advice and counsel that my colleagues and I and our firm have been providing to our approximately 350 association clients over the last year and a half has evolved. It's very much evolved. We spent most of last year, since March, helping associations and chambers and others get out of their meeting and convention contracts, in most cases without penalty, trying to rely on provisions like the force majeure clauses in contracts on the basis that it was illegal or impossible or commercially impractical to hold a meeting due to various state and local governmental restrictions on large gatherings. Those days are largely gone, even though we still hear from some clients even this week looking to get out of their conference contracts for later this year because their board just doesn't feel comfortable holding an in-person meeting. And as I've had to tell them, unfortunately, the 2020 is thankfully behind us, but so are the days of being able to get out penalty-free from contracts based on force majeure. That's just not going to work anymore. And while I certainly have a great respect for any board that doesn't feel like they are ready to have an in-person meeting yet, especially a large one. Legally, that's a different story, and you're not going to be able to get out of that contract, and most hotels and convention centers are not going to let you get out of that contract simply because your members don't feel comfortable attending or whatnot. So what we're having to do in those situations is to find some other leverage to negotiate their way out of the contract. Rebooking another meeting in the future instead, perhaps with larger minimum commitments for food and beverage and things like that, so it's more profitable for the hotel. Sometimes booking 2 additional meetings. Sometimes it's negotiating some lesser amount of cancellation penalties that some more well-heeled organizations are willing and able to pay. Sometimes it's holding new meetings and giving a larger advance deposit in lieu of cancellation penalties. So at least you're not throwing that money away, but you're giving more cash to the property at this time. There's lots of different tools. There's no easy silver bullet solution. That's kind of one bucket of issues for organizations that are locked into contractual commitments for meetings and contracts, but they don't want to hold them. There's another bucket that you guys might be experiencing, which is you contracted for a meeting a year ago, 2 years ago, say pre-COVID. The meeting's scheduled for summer or fall or later this year. And while you're excited to have the in-person meeting, and I was at an in-person meeting last week in actually, Paige, in your state, in Chattanooga, very successful in-person meeting. And there's a lot of organizations that are planning for meetings like that, but they are expecting to have lesser attendance than they originally contracted for, because you still will have some people who are just not ready to attend, say, especially this summer. That's what we're seeing across the board. So the concern is not about canceling the meeting and getting hit with cancellation penalties. It's about having lesser attendance and therefore not meeting your contracted for minimums for sleeping room revenue and food and beverage revenue. Those are called attrition penalties. When you fail to meet those minimums by a certain percentage, you can get hit with some pretty significant attrition penalties. And so what a lot of our clients are doing now is negotiating with the properties to try to get them to either waive the attrition penalties or reduce the minimums or reduce the amount of the penalties. Again, sometimes you got to give something more in order to make up for it. Most hotels aren't just going to lower those out of the goodness of their heart, unless you have a really strong relationship, long history, things like that. We are seeing some of that happen too. But you really need to keep that in mind. Even the meeting I was at in Chattanooga, while they had good attendance, it wasn't the amount that they had originally contracted for. It was lesser, but the executive director was able to, because of a longstanding great relationship with the head of the CVB in Chattanooga, was able to eliminate any attrition penalties from the contract. So you got to keep those sorts of things in mind. Now, in terms of holding in-person meetings and potential liability issues for the association, for the chamber. So and I've been giving the same guidance, from the first time that in-person meetings have been contemplated, which frankly is at least 6 months ago, if not longer. A number of organizations have started to contemplate and have held some in-person meetings. And basically, in terms of potential liability risk for the chamber, if someone attends, has the virus, transmits it to others, could your chamber be held liable? In order for your chamber to be held liable for that, well, there's the issue of causation. Can you prove that someone contracted the virus at your event? And that's always a difficult thing to prove. But if you had a cluster of outbreaks, it could be easier to prove. But beyond causation, then the real question is, was your chamber negligent in how it conducted the meeting? And that's the only way you're going to be held liable, is if you were negligent. So what does it mean to be negligent? So you have to be negligent. It means you failed in a material way to meet the prevailing standard of care at the time, the standard of care for how you conduct in-person meetings. That standard of care has evolved, right? Last year, large meetings were prohibited by most states and localities, cities, counties. And so if you were to hold a meeting in contravention of those laws, that would certainly not be meeting the prevailing standard of care. So the first thing you do is you look to any binding laws, regulations, executive orders that apply to the geographic area where you're holding the meeting. And there are some. Most states and cities and counties have lifted all of their restrictions against large gatherings now. not all, but most have. But some still have certain protocols that you have to follow. All of the stuff from the feds on the federal side is all advisory in nature. It's not binding, but it's relevant, as I'll talk about in a second. But you first look at what is legally binding. And at whatever protocols exist at the state and local level, talk to your attorney. You obviously need to make sure you comply with those if you want to meet the standard of care. And then you go to kind of what is advisory in nature. And that's where you go to the CDC guidance. And the CDC has guidance on large gatherings. You can find it easily on their website. They continue to update that guidance. I actually haven't looked at it in the last few weeks since a lot of these restrictions are lifted. So I don't even know exactly what it says at the moment about large gatherings, but you certainly want to try to comply as much as possible with the guidance that the CDC has. There's a lot of it that they have. A lot of it applies to the venues where you're holding the meetings, like the hotel, sanitation, air filtration, things like that. But some of the guidance does apply to the meeting sponsor as well, like you guys, the chamber holding the meeting. So to the extent you can afford to do it, that it's practical to do it, you want to try to follow that guidance to the greatest extent possible. Now, that's where we get the question about mask wearing and vaccinations. And I've gotten this question quite a bit. So far, what we're seeing in terms of kind of patterns amongst associations and chambers is that most so far are not mandating vaccinations as a precondition to attendance at a meeting or conference. Some are encouraging it, but most are not mandating it. And for those that are mandating it, so far we've just seen kind of voluntary self-attestation, just asking someone, do you attest that you've been vaccinated, not asking for proof of vaccination. Does that mean, however, that you could not mandate vaccinations as a precondition of attendance? No, you absolutely can if you want to. One thing you have to be careful about, there are a small handful of states, Florida being the most prominent, that have passed laws that make it illegal to ask for proof of vaccination for essentially like patrons of restaurants and stores and things like that. It's unclear whether it applies to attendees at meetings and conferences, but I think there's an argument that it does apply. So if you're holding a meeting in Florida, for instance, or the other states that have such requirement or such bans, you can still require vaccinations as a precondition, but you cannot ask for proof. So just keep that in mind. But generally speaking, in most states, you could if you wanted to. And you could also, therefore require unvaccinated attendees to wear a mask if you wanted to. That's not how it seems to be going for most associations. The meeting that I attended in Chattanooga, no one was wearing masks. Now, part of it is the state, as you know, Paige, culturally, there's definitely not, it's not a mask wearing state, put it that way. But at the same time, my guess is that, the vast majority, if not all of the attendees were vaccinated. And if any were not vaccinated, they were coming at their own risk. And the vaccinated folks like myself, felt safer. So that's just the reality, what's going on there with masks and vaccinations. In terms of liability waivers, again, I've gotten this question a lot. Can we ask our attendees to sign or click and accept that they agree to a liability waiver? Basically saying, I recognize that COVID-19 is a very serious virus and that it's easily transmissible. I realize that by attending this event, there's a risk that I might contract the virus. And if I do, I agree not to hold the chamber liable. Can you do that? Yes. Should you do that? I think yes. I think it's a no-brainer, unless you think it's going to really offend your attendees. But to me, it's a no-brainer to build that into the registration process. Those sorts of liability waivers don't always get upheld when they get challenged in court. Sometimes they get tossed by court for various reasons, but a lot of times they are upheld. And to me, it's a no-brainer that you should do that. And then you also should accompany that waiver, in my opinion, with something that basically says, I agree to abide by all of the chamber's rules of attendance. So whatever protocols you might have in place. Now, granted, those protocols are changing. In the past, it was all about mask wearing at in-person events. That's obviously changing now with the vaccines. But whatever your rules are, you want your attendees to agree that they agree to abide by those. So anyway, that was a long answer to your question, but I hope that's helpful.
No, that's great. And kind of staying on the same wave of waivers, do you need to be consistent with the type of waivers that you have for all of your events? So maybe it's a standard one that's used for all events, or would it just be for certain type of events, or should it just be a blanket for all of them?
I don't think it really matters. I mean, it's really up to you guys. I mean, to be legally effective and binding, the liability waiver should be clear, so that people understand what their, what legal rights they're waiving. Don't make it with so much legalese that it's too hard to understand. Make sure that the individual is releasing both the chamber itself as well as its officers, directors, and employees, things like that. But I mean, so the basic liability waiver, to me, it should probably be the same for most, just because I'm not sure why you would change it up. But if you felt there's some good reason to, that as long as you meet kind of the basic protocols for an enforceable liability waiver, I think you'd be fine.
Sure. And do we need to be having these people like physically sign the waiver, or can it be something that they're checking a box when they register for an event that says, I agree to X, Y, and Z?
Yeah, it can definitely be the latter. That's how
Okay.
most associations have been doing it, with like a click and accept box. But unlike in the past, we've written things into all like the terms and conditions of attendance at a conference. Things like you agree to release your right of privacy so that we can take photos and videos of you and use them without your permission, that sort of thing. And we usually bury that, not trying to bury it, but it's just in the rules and conditions. And we say by registering you agree to all of these rules. Here, because it's a more express liability waiver, it's recommended that there's some affirmative click and accept. Maybe it's a pop-up in the online registration process or whatnot. If you have on-site registration, you could do it the same thing if you have the capability to do it electronically, or just do it the old-fashioned way on paper. But yes, you can absolutely do it electronically if you like. And that's
Yes. When you mentioned that Tennessee was not a very big mask wearing state, you were not underestimating that. It's been really challenging for us here because we've had 95 counties in Tennessee, and only 6 of them have been able to implement a mask wearing, you have to wear a mask, all of that, aside from the governor's order. So it's been really challenging for us being a regional chamber, having 10 counties, and you only really can mandate a mask in one county, which is where we're located. But, the next, county or over, it's not a thing. And so it's been really challenging for us to kind of, navigate that. And especially going back in person, it's, what does that mean? So,
when I should have mentioned that you have to look at the local restrictions to see if there is in fact, a ban on private entities requiring mask wearing.
right.
For the same issue, goes to the asking for proof of vaccinations. It's the same thing. And now, I mean, it's going to be interesting to see how all of this evolves. That was an interesting experience. I was at that same organization's annual conference last August in Savannah, Georgia, and there was very different. Everyone had masks on, the entire time, except when they were eating or drinking. So things are evolving, but I think you're going to see a lot of kind of hybrid, between the two of those. But a lot of it is no question it's influenced by where you're located, not just what the laws say, but kind of the norms and cultural atmosphere there.
Exactly. So kind of staying on the same topic of waivers, do you have like a couple of things that definitely should be included in a waiver, or possibly an example of a waiver that you could share with us either later or through the chat?
Yeah, I will. I know I sent this, I think the last time we did this, but I will send you, I have a model COVID liability waiver on our firm's website. Kind of link to an article about liability waivers. I'll send that to you. I also have some other samples that we've kind of culled together that are good samples if you want to see different variations of how to do it. Those are a little more robust, but I'll send those to one of you guys and you can just circulate them to the whole group.
That sounds awesome. So you mentioned following CDC guidelines. I'll just use Tennessee as an example. Our governor has been very outspoken about it being very open state. The crisis is over is something that he's said several times. How do you balance kind of that aspect of, needing to follow CDC guidelines, but also being in a state where things are completely wide open? Is it better to say if you're fully vaccinated, you're welcome to attend? Or what are your thoughts kind of around that?
First off, that's the $1 million question, whether we should require vaccinations. I can't give you my, opinion on what's the right or wrong thing to do. I can just tell you what's legally permissible and what the legal, boundaries are. I would say, certainly whatever is binding in the state or the city or county, you obviously have to follow. CDC guidance is voluntary, although it goes to what that standard of care is. I suspect that the CDC guidance still probably encourages mask wearing in large gatherings. At least the last time I looked at it, it did. I don't know that has changed. I doubt that has changed. But you're right. That runs, headstrong into, certain states where the cultural norms are very different. But I think we're getting to the point from a legal perspective. If you encouraged your attendees to be vaccinated and you encourage them to wear masks if they're not vaccinated, from a legal perspective, if someone later contracted COVID and then tried to say that you were negligent, I think that'd be a very difficult claim for someone to make.
Sure. So kind of around the same vein of looking at things that have been longstanding. So in terms of looking at someone from an ADA perspective, has COVID created any new considerations around being ADA accessible for events?
So it's a great question. And we have to distinguish, I was going to talk about this, between the rules and the legal construct governing employees and employment versus attendees at a conference. And of course, like you guys, I think, or most of you or all of you are staff at your chamber. So when you're attending your chamber's events, you're still governed by those employment laws. Whereas attendees attending an event who are not employees of yours, most of the protections under federal and state employment laws, including the ADA, Americans with Disabilities Act, do not apply to conference attendees. There's not that same level of protection. Title VII of the Civil Rights Act does not apply, things like that. So I'll talk about the employment setting in a minute. There is one title of the, one section of the ADA, Title III, which applies to places of public accommodation, like hotels and convention centers. And this law has been around for 25 years now. There's a lot of precedents there. And what it basically says is that if someone has a qualifying disability, that both the meeting sponsor as well as the venue are obligated to provide and make a reasonable accommodation for that person to be able to attend and participate in the event, so long as it doesn't pose an undue burden on either the hotel or the sponsoring organization. So in the past, this has been things like, sign language interpreters and, accessibility aids for hearing and vision and other things like that. As well as on the physical properties, things like, ramps and elevators and things like that for folks in wheelchairs. And that's typically been how the ADA has applied in the meeting and conference setting. Now, it's unclear, if someone has, say, a medical condition that qualifies as a disability that prevents them from getting vaccinated, but they still want to attend your conference. What are you going to have to do to make that reasonable accommodation? It's unclear. It's very much unclear. Could you say, we're going to take all the educational content and put it on our website later and you can access it that way? Is that enough of a reasonable accommodation? It's really too soon to say because, this stuff hasn't played out yet. And whether there's going to be legal challenges, court challenges, we're going to have to wait and see. But it's very speculative at this point. But that's really the only place that the ADA applies. But because the ADA does apply in this setting, one thing to keep in mind is that if you are going to ask for people's vaccination status, regardless of whether you ask for proof, based on the guidance that the EEOC has put out in the employment setting, it's important that you not share that information with anyone other than kind of on a need to know basis. Basically, if your senior staff is asking for that information, don't share it with anyone else, because there are protections under the ADA for medical, personal medical information. And the EEOC has said it's okay, even in the employment setting, to ask your employees if they're vaccinated, even to require proof, but you can't share that more broadly. That can turn into a violation of the ADA. I got the question in Chattanooga last week, and I've gotten it a few other times about, isn't it a HIPAA violation if we ask for that information? And the short answer is no, because you're generally not going to be covered by HIPAA. HIPAA applies to healthcare providers and certain business associates of healthcare providers, but it's almost unfathomable that chamber would be considered to be governed by HIPAA. So it's not a HIPAA issue; it's an ADA issue. In the employment setting, you have the ADA. There's another title of the ADA that applies to employment. So the same basic issue about sharing employees' vaccination, information. You got to keep it in a very close circle, keep it confidential. And if someone has a qualifying medical condition that makes it, say, unsafe, or they're unable to get a vaccine, you are obligated to make a reasonable accommodation for them, so long as it doesn't pose an undue burden. With the most obvious reasonable accommodation being allowing them to continue to work remotely. Now, the one little wrinkle that we've dealt with some clients is, well, look, we're bringing everyone back to the office. We're having in-person meetings. I had this a couple weeks ago, a question from a client. They said, we have this one individual and her sole job is basically going around and staffing these in-person meetings. And they're a small staff. They don't have someone else who could take over those duties. And they're not sure if her if there's some medical reason why she's not getting vaccinated, or it's just a political issue, or she's just scared of it, or whatever else is driving the decision. But it's a really tricky issue. In that situation, if working remotely is not an option to make a reasonable accommodation, because the ADA says you have to make a reasonable accommodation so long as it doesn't pose an undue burden on the employer, so long as with that accommodation, they can still perform the essential functions of the job. And here, because the essential functions of that job require you to be there in person, the same thing could arguably be said for a receptionist at an office, greeting people coming in from, the person that delivers the mail. You're talking about larger organizations, but in those situations, even if someone did have a qualifying disability in that situation, they could probably be terminated because they can't perform the essential functions of the job, even with that accommodation. The other law that does employment setting is Title VII of the Civil Rights Act, which prohibits employment discrimination on the basis of a number of different protected characteristics. In this setting, the protection against religious discrimination is the operative one. And there, what that means, and what the courts have said is that, and what the EEO has said is that if someone has a sincerely held religious belief that prevents them from getting vaccinated, then it's the same basic legal construct under the ADA. You have to make a reasonable accommodation unless it would pose an undue burden, and so long they can still perform the essential functions of the job. It's a little bit less strict of a requirement under Title VII, but it's the same basic construct that applies. But other than those two things, if you have like a mandatory vaccination requirement, which some employers are doing. I wouldn't say the majority by any stretch, but we've seen it from some of our clients. Some are doing it. What's more common is to say, if you are vaccinated, you don't have to wear a mask in the office. If you're not vaccinated, you do have to wear a mask. That seems to be kind of following basically the CDC's guidance from a few weeks ago. That seems to be in the nonprofit community kind of the evolving norm. At least in DC here where I'm located. And I've seen it elsewhere. But there, if someone doesn't fall into one of those two buckets, if they say, I politically am very much opposed to vaccines and to masks, and you're discriminating against me, by making me wear a mask in the office, you could do that if you wanted to, and you could terminate them if they refuse to wear a mask or get vaccinated.
Yeah, Jeff, that's right along the lines of kind of what we're doing. Our office actually moved last July. We had been working remotely since last March. We are now fully back in the office as of June 1st. And we have not been mandated to have vaccines as staff, but if you are not vaccinated, you do need to wear a mask. And so we're, kind of following the CDC guidance to a T in terms of who can be without a mask, who can be, around people, and still keeping people, as distant as possible, but also realizing we've got to kind of ease back into things as best we can. So, and the question has come in terms of, let's say you have an event, masks are required, who bears the responsibility of keeping, mask? Does the chamber need to purchase, 500 masks in case, the majority of your people come without a mask? Is that the venue that you're in, or is that the person's responsibility if you put it out there that masks are required? What are your thoughts there?
Well, I mean, first, you're talking about a mask requirement for attendees at an event.
Yes.
So you're saying if someone wants to mandate that everyone wear a mask,
Right.
regardless of vaccination status.
Yeah. And that may be a little bit, since the mask thing is, being really phased out in a lot of cities. But if there was a surge or something, or if there's a venue that said everybody need to be masked, who would bear that responsibility?
I don't know if it's illegal. It's not a legal responsibility I mean, masks are so easy to get now. It's not like the beginning of the pandemic. And they're so inexpensive to purchase. But regardless, if you're going to have that sort of requirement, I would say just purchase, 100 or 200, whatever the number is, disposable masks. They're so cheap these days. That would just seem to make a lot of sense. Just like, you see most restaurants and businesses that still have mask requirements, making them available to people who might have forgotten theirs or whatnot, which does happen. But I don't see it as a legal issue. But Paige, you and I had spoken right before this thing started about how you guys are dealing with these issues in your workplace, which just reopened, I think you said on June 1st. And you gave an example of like an employee who hasn't been able to get vaccinated yet, not for a lack of desire, but I think because of previously having COVID or something like that. I think it might be illustrative to the group to talk about how you guys are handling that. Some of this is legal, but some of it is just staff morale, employee relations. I had one of our largest clients, got an email yesterday. They announced kind of the same kind of policy I just described a couple of days ago, that if you're vaccinated, once the office reopens in a month, you don't have to wear a mask. If you're not vaccinated, you do have to wear a mask. And someone complained that essentially it was unfair to them. They're going to be singled out. They're going to be ridiculed, because they might be one of the only people wearing a mask. And while right now the current legal thinking is, again, unless someone falls on one of those protected categories, that there is no legal right, against, feeling ostracized because you're wearing a mask. Now, granted, if it turned into a hostile work environment, that's a whole different situation there, that it could trigger some rights under the employment laws. But generally speaking, there's no legal right to not feel embarrassed by being the only one wearing a mask. But at the same time, you're humane employers, and you want to, do right by people and not make anyone feel uncomfortable. So do you want to talk about how you've handled that?
Sure. Yes, we have, our staff is about 40 people in total. We have one staff member that has not been able to get vaccinated. We as a chamber have not required our staff to get vaccinated, but it has been strongly encouraged. So if you were not vaccinated by June 1st, when you come into the office, you were asked to wear a mask and kind of do what we were doing, before June 1st, in terms of wearing a mask, remaining socially distant, all of those good hygiene things. So the reason why she hasn't been vaccinated is she had COVID back in January, had some pretty serious complications. So she has been able to come into the office just like everyone else. And it's really been more a comfort level for people. So like she and I went to a function yesterday. I'm fully vaccinated, but I said, I don't want you to feel weird being in a group of, 15 people without who don't have a mask on and you be singled out. I'm going to put my mask on too. We've done that in the office when we've met in person within groups, just as a common courtesy, so she doesn't feel singled out. And it's more or less just making sure she feels okay, because she did have a really tough go of it a few months back. So really glad that she's healthy and safe and even able to be with us. But just, it's been more about like making sure that we are comfortable and less about like, oh, show me your card. Are you vaccinated? Do you have a mask on? More about kind of the human aspect that Jeff was talking about. So really trying to make sure that we care more about the person than just the outward appearances of, mask or vaccine cards or anything like that. So any other questions that you all may have, make sure to put them in the chat and I can toss them over to Jeff as well. A little bit more about, traveling. I know our chamber does a large intercity visit every year to a different city. We were headed to San Diego back in April of 22 or April of 2020, we thought this would be over. And so we moved it to August, then we moved it to 2021. Now we're in 2022, primarily because of how California has shut down and been very slow to reopen. Any implications if chambers are taking trips, things that they should think about with air travel or bus that may be different than if they are meeting in a meeting space within their city that they are located in?
Well, I mean, for your staff, most employers seem to be heading toward whatever policies they have in place for coming into the office also apply for staff travel. So that if of course, you always have to comply with whatever existing laws apply. Like, for instance, the FAA still requires masks, in airports and on airplanes, regardless of your vaccination status and regardless of the CDC guidance. And so that obviously is always going to apply. In public, on a lot of state and city public transportation systems, same thing. But beyond that, most employers are putting the same requirements for staff travel as they do with respect to staff coming into the office. And so we don't need to revisit that whole discussion that we just had, but just apply it to that setting. In terms of attendees, if you're worried about the potential liability risk for your attendees contracting COVID on the way there, I really wouldn't worry about that. That's beyond your control. I don't think that's within your duty of care. You're not obligated to provide a safe, unless you're requiring them to travel through some really unsafe means or something like that. But if you're talking about standard commercial air travel and trains and buses and things like that, I don't see how you have any legal duty or obligation.
Awesome. So Andrew, our friend from San Antonio, has an international trip scheduled in October to Egypt. What are your thoughts about, the U.S. has done a fairly good job the last couple of months with vaccine rollout, infection rates, but you're maybe going to a different country or maybe connecting through an airport or city or country that may not be, as good of shape. Anything that we should be looking for, traveling internationally?
I think you follow the State Department guidance, and the State Department has issued guidance and updated it. I don't know if the CDC has as well, but I know the State Department has with respect to COVID. They have countries. I think I might have seen a headline yesterday that said a bunch of countries are lifted, from the do not travel list for COVID related reasons. I could be wrong, but I think you basically look to that, because if the State Department says don't travel to India because it's a COVID hotspot, and then you send someone anyway, the employer sends someone and then they contract COVID there, I think that's a problem, because it's that standard of care. Are you being negligent and not following prevailing guidance? And, their State Department historically has been pretty good about, they have different levels of ratings about how dangerous it is, like in certain, war type conditions and terrorism and things like that. But I think if you follow the State Department guidance and any applicable CDC guidance, I don't think that's an issue. Of course, if someone is vaccinated, whoever's going to do the travel, I think that's a much safer situation as well.
Sure. So just keeping in line with, the liability waivers that we may already have in place, and just making sure they encompass the risk of travel in a pandemic or something like that.
No. So liability waivers, I'm glad you mentioned that. That was with respect to attendees at your conference.
Okay.
Liability waivers by employees are generally not enforceable because in most states it's illegal for someone to waive their worker compensation rights. And if an employee were to contract COVID on the job or in connection with work travel, in most states the claim would be brought under the workers' compensation system in that state. And so you should not be asking your employees to sign liability waivers. But you can mandate certain protocols, right? If you're sending someone to a country and it's known that one part of the country is a real hotspot for COVID, or for frankly anything else that's dangerous, fighting going on, like is going on in Israel and the West Bank and Gaza right now, or other things like that. For anything that's risky, you should advise the employees, do not travel even on your own time, to this place or that place, and to stay in these safe areas, or, don't, whatever the situation might be, whatever good guidance you can give and mandate to that employee so that you're not being negligent in how you carry out the meeting, you should do. And actually reminds me, one thing I forgot to say earlier, kind of switching gears back to your meetings, I said that a lot of the CDC guidance relates to the venues and what they're obligated to do. One thing that's important to do is to make sure you get the venue to agree that they are going to follow the CDC protocols to the greatest extent possible with sanitation and ventilation and other things like that. That's very important. Even if you don't do it as an amendment to the contract with the hotel or whatnot, at least through an email exchange or something, get them to agree, to at least certain minimum things that they're going to agree to do. It's going to create a safer environment for your attendees, how food is served, all of that kind of stuff. That's a big one. Having just been at an in-person conference, there was like a buffet lunch, or a couple of them, but they made sure that there was kind of screens, kind of plexiglass screens in front of the food, and everything was being served by someone behind the screen. You weren't just taking your own stuff like you would in the past. Things like that. Get the hotel to agree that that's what they're going to do. If you want to have more social distancing, that did not happen in Chattanooga, but in some places, a lot of organizations are going to want to have more social distancing. And so get the hotel to agree to those things. It'll create a safer environment for your attendees, make them feel safer, and it helps to show that you are not being negligent in how you carried out the meeting.
Yes, and we actually just signed a contract for an event in the fall, and there was a whole section in the contract on what that hotel was going to do in terms of safety protocols. So that made us feel really, safe and secure, thinking, even in October, this is what they're committing to now, and whether things change or what they look like going forward made us feel really good. So you mentioned serving food. I think there's a joke within the chamber community about there being chamber chicken. Thinking through how to mitigate that risk of maybe it's not the greatest thing to have food just out as a free for all. Is there anything we should be thinking about as we are contracting food and beverage?
Yeah, it's not a good idea to have, buffets open for people to grab their own food. That's just while COVID is still with us, and it likely will be for a while, hopefully not at this level for too long. But right now it is absolutely still a CDC recommended practice and a standard, part of that standard of care, that you go through proper protocols. Now, does that mean you have to put every lunch or dinner in like a boxed lunch, like I've seen at some places? No, you don't necessarily have to do that. But you don't want a situation where, people are self-serving their own food from a buffet line or from a snack table or something else. If there is going to be, snacks at a break or something like that, make sure it's all kind of prepackaged stuff. If people are going to be able to grab it on their own. Not something loose that people could breathe on or sneeze on or cough on or something like that. If you're going to have a buffet line, like I said, make sure the venue puts some kind of shield in front of it, and that it's all being served by their staff and whatnot. That sort of thing. If you're going to have a sit down meal and have, if it's at a restaurant or a caterer, and they're going to have people bring, the plates to your table, I think that's fine as long as the servers are wearing masks. And that's another thing too. It is still very common, even in states like Tennessee, at least at some of the places I went to when I was in Chattanooga, some places still require all the staff to wear masks, even though none of the patrons were wearing masks. In some other places, it's not the case. Like none of my Lyft or Uber drivers in Chattanooga were wearing masks, except one, the last guy. So keep that in mind, though. If you want to mandate that, you need to put that in your contract. Now, granted, not every venue is going to agree to that if they're really opposed to it, or if there is, again, a state or local law that prohibits it. But that's something to keep in mind.
Most definitely. And I think, too, a lot of it goes to kind of the comfort level of wherever you are and kind of who your clientele is. Kind of bringing this into a little bit more of a broader view. Are there things that you're seeing within nonprofits or associations or just in general of like big pitfalls that we should be thinking about, whether it's COVID or not, just, in general with legal pitfalls that we need to be thinking about?
Not anything beyond what I've already talked about. I think we've kind of covered the waterfront pretty well of kind of the current kind of COVID-related legal issues and challenges, and both on the meetings front and the employment front. I am sure things will continue to evolve, and there will be litigation and whatnot, but I don't think there's any big, legal pitfalls or anything that we haven't already addressed. One thing I do want to comment on that's really important in terms of your kind of toolbox of risk management is insurance. Insurance has always been important because it helps. It's a safety net, a financial safety net, in the event something goes wrong, and whether it's like property insurance and your property gets damaged or lost or stolen, or whether it's commercial general liability insurance for a slip and fall, incident at your conference, or whether it's directors and officers liability insurance that covers things like employment claims against your association by disgruntled employees. Or event cancellation insurance coverage that can protect you for certain cancellation or reduced attendance at your events. These are all kind of different tools in kind of the toolbox of risk management. They're all very important, but a couple of things to keep in mind. Insurance has gotten a lot more expensive. For any of you who work on your insurance policies and premiums, if you've gotten your renewal bills, in the last probably almost 12 months, certainly the last 6 months, you're seeing a significant hike in premiums. We're seeing 20 to 30% hikes from the prior year in premiums. That's a lot. And it's not all COVID related. Some of it is. Some of the carriers took some big losses in connection with COVID. But a lot of this, from what some of the leading kind of association insurance brokers tell me, these are trends that were going on in the insurance market pre-COVID, and then they've just escalated and continued. Another thing that we're seeing, and so make sure you have a really good insurance broker who's able to go out into the market and shop you guys around to try to get the best. There's competition for every insurance policy, and a good broker will know how to shop it around and negotiate to get the best deals for you. And sometimes, like, I have one client they're really unhappy with their premium hikes, and they pay a huge amount of money for insurance. So they're going to get rid of their broker, and they're going to shop it around for a new broker. And I gave them some referrals, but you got to have a good broker to get good insurance, and don't underestimate the importance of it, and make sure your broker really understands kind of the world of chambers and associations, because it's a very different market than a for-profit business. And those can be hard to find in some cities and states because a lot of brokers just don't have that experience. The other thing that we're seeing is COVID-related exclusions from insurance policies. So you can no longer purchase coverage for what's called communicable disease, including COVID and other viruses and communicable diseases. You used to be able to pay a higher premium in order to secure communicable disease coverage in your event cancellation insurance policies. And a number of associations had that. And we have one client that got, I think, an $11 million payout for their annual conference being canceled last year. They did have they did purchase that coverage, but you can no longer purchase it. None of the carriers of event cancellation insurance, they're excluding all communicable related disease claims from coverage. And the same thing we're seeing now with commercial general liability insurance, which is that kind of slip and fall insurance that I talked about that has typically been of greatest importance at your conferences and meetings and other in-person events. If someone gets injured and hurt and files a claim against your association, against your chamber, that policy has always provided coverage, but now those policies will not cover any claims that arise from communicable diseases. So just something to keep in mind, and that's not likely going to change anytime soon, but it's something you should be aware of. That being said, all of those types of insurance are still very important. The one question I've gotten a lot is, well, if event cancellation insurance doesn't cover COVID, and if it's gotten even more expensive, is it still worth it? And I can't answer that question generically, but I will say if one or more of your conferences, especially if you have one big one like your annual conference, that's a materially significant source of revenue for your association each year, it's probably worth really seriously considering getting event cancellation insurance, because there still are a lot of other perils that are covered by that, from floods and hurricanes and fires and things that we've seen all in the last year, having nothing to do with COVID. Those things, strikes, terrorism, those things can still happen. And it's something to keep in mind that it's still worth looking into that.
Yeah, and I'm glad you mentioned insurance. We actually just had our annual meeting with our insurance provider a few weeks back. And it was a good reminder for everybody to remember to get a certificate of insurance from all of your vendors. So it's like if you have like bartender, catering, venue, and I think we kind of take it for granted that everybody just has insurance. And so they were really, harping on make sure you have proof that everybody has it if they're a vendor for you. So
Yeah, and that's something, so we, as you can imagine, do thousands of contract reviews every year, all different types of contracts, including those sorts of vendor contracts and whatnot. And that's something you want to make sure is written into your contracts, that you require them to maintain particular types of insurance, sometimes even specifying in minimum dollar amounts, and then sometimes requiring, like your broker recommended, that they provide you a certificate of insurance that covers your meeting dates. And then sometimes some of our clients insist on the venue, for instance, naming your chamber as an additional insured on their policy. That's something that's generally fairly easy to do and generally doesn't cost anything or much extra for them to do. I can't tell you it's absolutely essential that you always do it that way, but it's something that we see quite a bit.
Perfect. Well, this has been incredibly informative, Jeff. I know you've given me several nuggets to think about kind of as we are thinking about reopening and going back in person for events. So thank you for your time. It's been super valuable for me to chat with you. And I know everybody else feels the same way. I will now turn it over to Emily Counts with ACCE to provide closing remarks and share some important information with us about the summit coming up.
Awesome. And before I say my little spiel, thank you so much, Jeff, for taking the time today. This has been super helpful for me, and I know for a lot of different people. So thank you, thank you, thank you. And also, can we just get a huge round of applause for Paige for asking such insightful questions? I did not give her a whole list of questions. She came up with this by herself and also from y'all. So thank you, Paige, for taking the time today to just be so thoughtful in the questions that you were asking.
You are welcome, Emily, anytime.
You did do a great job, Paige. Those are great questions.
Thank you.
She's an all-star. It's why we ask her to do these every once in a while. So Susan just sent a message through the chat of where to find the recording for this call, because as I am sure some of you are aware, we did just change over our system. So it's not going to be on our events division page anymore. It is going to be on our events division course in the online learning platform, and the link is in the chat. And Susan will also be chatting the link to our summit registration. So we are not doing an in-person conference this year. We are going to do one more fully virtual conference. It is July 19th through 21st, and we have some fabulous sessions for y'all. And you can check out the agenda, and we will be updating that more as we finalize those sessions in the weeks to come. And you can just get a sense of what that event is going to be on the link that's on the page. So that is all I have for you, but thank you so much for everyone for asking your questions and for hanging out with us today. And I hope to see you on our next events division call. Thank you so much and have a great rest of your day.
Bye.